Live from Washington, D.C., Jay Sekulow Live. Phone lines are open for your questions right now. And now, Chief Counsel for the American Center for Law and Justice, Jay Sekulow.
Everybody, welcome to the broadcast, and it's a good way to start this broadcast. We've got a nice win out of the U.S. Court of Appeals for the Sixth Circuit. Now, this case involved the national motto, "In God We Trust." There's been a series, as you know, a series of challenges to the national motto. We've been litigating this, my goodness, for three decades. But what's interesting here is this decision just came out late last night. Here's what we argued in our brief that was filed on behalf of members of the United States Congress, and, of course, our American Center for Law and Justice and our committee to defend the national motto, which many of you were members of. I'll get the exact number. I think it was a couple 100,000 people. We'll get that. But anyways, here's basically the four arguments we made. Number one, the national motto does, in fact, reflect the historical fact that this nation was founded upon a belief in God. Number two, the First Amendment does not compel the redaction of all references to God just to suit, in this particular case, atheists who were complaining about it. Appellants were arguing that they had a free speech claim to not have to see the national motto on coinage. We thought that was wrong. We also thought that they lacked standing to assert their claims. The Sixth Circuit Court of Appeals issued a decision today, or last night, affirming the lower court's dismissal of the case, which held that, in fact, the national motto, "In God We Trust," on U.S. currency is, in fact, constitutional. I want to get your opinions on this, folks, because it's kind of a core ACLJ case. That we've been handling these cases. As you know, I've been litigating these cases before the Supreme Court for 3 decades. And we've got now another win here. Now, I think the next stop on this one is probably the Supreme Court of the United States. We represented members of Congress. How important is it to you that we continue to defend things like the national motto? Andy Economou, Senior Counsel for the ACLJ. Andy, I go back to 1987, and or 1986-104 was our first free speech religion case at the Supreme Court of the United States, Board of Airport Commissioners versus Jews for Jesus. We did that out of your office in Atlanta in those days.
That's right. That was done out of a small office on Peachtree Street in the Rhodes Haverty building, but it was a unanimous win by you, who argued the case in the Supreme Court of the United States.
Logan, do you remember that office?
Vaguely.
You were 2 years old.
Yeah, I mean, flashes.
You came in a couple of times. Yeah, it was a small office, but the office,
was already working.
Didn't matter how small the office was. The end result, as Andy said, was a 9-0 case. You know, put that on fast forward now. It's a little bit of a bigger operation, to say the least. And in this particular case, Than Bennett, our Director of Governmental Affairs, we represented, in addition to our members, we represented members of the United States Congress.
Yeah, this is one of those issues, Jay, that members of the Congress have stood with us on many times. In fact, if for people that come to Washington, D.C., Jay, and visit the Capitol, when they walk into the Capitol Visitor Center, the national motto, "In God We Trust," is emblazoned in giant 3-foot letters on the steel beam as you entered those doors. Jay, that only happened because we defended against a lawsuit alongside members of Congress the inclusion of that national motto, which the statute required. This case is very similar. It involves currency, but the bottom line, it is a defense of the appearance of the national motto in public spaces and on public items. In this case, it's currency. So members of Congress of both sides of the aisle, Jay, they have historically stood with us. And quite frankly, it's important because they're the ones that draw the statutes that in many cases, including the Capitol Visitor Center, authorize the inclusion of the motto.
Hey, we've got a petition up as we continue to defend the national motto. You could join it. Over 320,000 of you have defending the national motto. 877-989-2255. That's 877-989-2255 or ACLJ.org. Again, if you want to sign up for that petition, defending our national motto, this one may go to the Supreme Court. 877-989-2255 or ACLJ.org.
It's happening again. Our national motto, "In God We Trust," is under attack in the courts. Those determined to banish our motto continue to make outrageous claims. Claims like our national motto is, quote, extremely offensive, quote, represents bigotry and persecution. The arguments are absurd. At the American Center for Law and Justice, we have successfully defended In God We Trust on numerous occasions. We defeated attempts to remove Under God from the Pledge of Allegiance at the Supreme Court and lawsuits against the national motto before. Now we continue the fight to counter the challenges to our national motto. Stand with the ACLJ in this important battle. Our national motto is ingrained in the fabric of our great nation. We will continue to defend In God We Trust, thanks to your support. Stand with the ACLJ now. Join the team that defends your religious and constitutional freedoms. Check it out online, aclj.org.
So here's what's happened. It was a challenge to the national motto, and the argument was that these individuals and atheist groups are distressed because they have to look at the coinage on the motto on our money, and therefore the In God We Trust is unconstitutional. And the district court said no and dismissed it, or ruled a 12B6 motion saying that ruling for the defendants. The case went to the Sixth Circuit Court of Appeals, and the Sixth Circuit said that, in fact, that the national motto, In God We Trust, on the coinage is constitutional. Now, does that mean the case is over? No, it probably means the next stop is the Supreme Court of the United States. That's my guess on this. This is what I call a core ACLJ case. This is the kind of cases we've been litigating for 3 decades, and this is a good win out of the Sixth Circuit Court of Appeals. Again, may well go to the Supreme Court, or they may take it en banc, which is to the entire Sixth Circuit. But right now, it's a nice win.
This is what we do. This is the heart of what we do. This is the heart of what brought us to the table as an important religious liberties law firm and organization that we represent. People such as those who were discriminated against, I believe, the vast majority of the American people. But you know what, Jay? This is nothing new. In 1952, the Supreme Court of the United States, in a case, Zorak versus Clausen, says what has been reaffirmed in this opinion of the Sixth Circuit today. We are a religious people whose institutions presuppose a supreme being. We guarantee the freedom to worship as one chooses, but we make room for as wide a variety of beliefs and creeds as the spiritual needs of man deem necessary. And that's an important statement that was made by the Supreme Court of the United States almost 70 years ago.
Justice O'Connor also made this famous statement in one of the opinions in a religion case I was involved in, and said that it would be ironic indeed if a nation founded by religious refugees would sever the ties that bind it to that heritage even today. And that was in reference to Under God in the Pledge of Allegiance. So these attacks go on. By the way, here's the interesting thing. So, Logan, when we signed, this tells you the power of the social media platforms we have. 120,000 people signed up for this brief when we filed it 15, 18 months ago. That petition now, or that group defending our national motto, is now up to 353,141 in just probably a year and a half or so. It's pretty amazing. And that's the power of the social media platforms.
Absolutely. We're able to get the word out to as many people as we can. And the most options, like I said earlier, you can really watch us, be a part of us, follow us, really see everything we're doing, everything from our website. But that expands out to pretty much every form of social media. We promote the Facebook and Twitter and Periscope often, but we're also on Instagram. We're also on YouTube. We're also everywhere. If you get media, we're usually there. We're on TV every week. The radio show, podcast, you can find our media everywhere.
All right, let's go ahead and take some phone calls. We want to know what you think about defending our national motto.
Mary in Fort Worth, Texas, you're on the air.
Hi, Mary.
Hey, I just wanted to tell you guys that it is very important to me, and I try to send you guys $100 several times a year for this very reason, and I do not do that very often, so thank you for the fight, and thank you for the victory so far in this one, and I appreciate it.
Well, Mary, first of all, thank you. We couldn't do it without the support of our members around the country, and your support keeps our lawyers engaged in all of these cases. And as you said, this is a core case, and I wanted to lead with it today. This is a good win. This is the defense of the national motto. And then here we had, and this is, I think, important here. Andy was pointing to the legal side of this, but we worked with Congress on this because these are statutes passed by Congress that became law when we talk about our national motto in the Engravement Act. So all of that allowed us not only to prepare a brief, but also to represent 120,000, now 353,000, which is just mind-boggling when you think about it, but also, members of Congress.
Well, I appreciate Mary's call, Jay, because when I go to a member of Congress, whether it's the United States House or the United States Senate, I basically go to them with two things asking for their support. I go to them with our legal arguments, in this case, the brief that we are about to file. And, Jay, then I also go armed with the signatures of the people who vote for them, their constituents, people like Mary who want their member of Congress to stand with us in these arguments. And those two things have to be in alignment for that member to stand with us. And in this case, you had almost 40 members of both chambers in a bipartisan fashion stand with him. I would just quickly give a nod to Senator Langford of Oklahoma, who led on the Senate side. And then, Jay, on the House side, Congressman Mark Walker from North Carolina, who you know has been very involved in Pastor Brunson's case. Yep. And he now is also the chairman of the very powerful Republican Study Committee. So you're talking about some of the most powerful members of both the United States House and the United States Senate. Jay, they're on this brief because of the merits of the arguments and because of people like Mary asking them to stand with us.
You know, there's another aspect of this that's interesting. I'm seeing a number of our cases, Andy, cited in here. That a couple of cases I argued at the Supreme Court. So we're looking through the opinion here. But I think what's important here is, number one, the end result is the motto was determined to be constitutional.
That's right, and that's the important thing. You have to look at what the case was all about, and that is that the motto, "In God We Trust," our national motto, has been declared to be constitutional. This is what the Supreme Court or what the Sixth Circuit in this case did again, Jay, is reaffirmed what our Supreme Court has said in a case as old as 1892, Church of the Holy Trinity versus United States. And I quote, "This is a religious nation." And again in 1984, "There is an unbroken history of official acknowledgement by all three branches of government of the role of religion in American life from at least when? 1789, the foundation of the Constitution. Religion has been closely identified with our history and government." These are the statements that are the core principles that the ACLJ has fought for and the Constitution provides.
Yeah, actually, the quote you read about this is a religious nation. Read that quote again, because I'll give you the rest of it.
This is a religious nation is how it starts out.
Yes, and then it says, whose institutions presuppose the existence of a supreme being. That's right. How the whole opinion in that particular case read. I mean, I've cited these cases for a long time, so that's why I'm not playing like Jeopardy here, where I'm going to get points for this, but I've been citing these cases for a very long time. Like I said, I've been litigating before the Supreme Court for 3 decades. I've thought about that the other day. I guess it's going into, if we get a cert grant in the case that we've got about to pen, it will be 4 decades. That means I'm an old guy. All right, go ahead, Logan. Let's take a call.
Let's go to Christine, who's calling first in Utah.
Hey, Christine, go ahead.
Hi, I have a question. And you might have just answered it. When you said that somebody doesn't have standing, does that mean that it's already been determined by the court?
No, the issue of standing is whether the person could actually bring the case to court in the first place. Now, we're just analyzing the opinion now. It sounds like they found some type of standing here because generally these cases get dismissed on standing. This one reached the merits, and what the difference is, if it's on standing, the first question you get asked often in Supreme Court oral arguments is, what is the basis upon which the plaintiffs have a right to be in court, an Article III court, the federal judiciary? And if you're representing the plaintiffs, you argue injury. What is my injury here? Well, the injury that they were asserting was they have to see the motto on our coinage, on our money, and that's derogatory to them. The court said, well, we're going to get to the merits of this and say that it's not a violation of your free speech rights, your equal protection rights, or your free exercise of religion rights. So the court got to the merits of the decision. In the national motto case, in Under God and the Pledge, they actually never got to the merits. They just dismissed it basically on standing grounds there. But, Than, you raised the issue, and I think it's important for people to understand that this is where our legal work coincided with our congressional efforts, which ended up in a decision out of a court of appeals right below the Supreme Court.
Well, and the arguments that are made that they feel physically ill, which is oftentimes what they make, Jay, is the argument that they will claim gives them standing. But we have to argue that the historical significance of the national motto means that it should exist. And I want to remind people of this. I'm going to give them a very physical example. If they come to Washington, D.C., and they want to visit the United States Capitol, they'll walk through the Capitol Visitor Center's doors, and one of the very first things that they will see is that national motto emblazoned. But, Jay, the inclusion of that motto was also sued by a very similar similar organization who said if our members walk into the Capitol Visitor Center and, oh my goodness, if they see the national motto inside the United States Capitol, they're going to be so offended that they're not going to visit the United States Capitol. That's, of course, a ridiculous argument. But, Jay, when the Capitol Visitor Center was constructed, they excluded the national motto for that very reason, because they were afraid of lawsuit. We had to go on behalf of our members and on behalf of members of Congress who passed that statute authorizing the inclusion to get it there. But if our members come to D.C. today, Jay, when they go through those doors, it's the very first thing they'll see when they pass through those doors.
You know, it's interesting because in the complaint it says, construed in the light most favorable to plaintiffs, the complaint alleges that carrying and completing transactions with currency containing the motto is inconsistent with the plaintiff's beliefs. And that's because it has the phrase, in God we trust on it. Hey, we've got a petition up as we continue to defend the national motto. You could join it. Over 320,000 of you have defending the national motto. 877-989-2255. That's 877-989-2255 or aclj.org. Again, if you want to sign up for that petition defending our national motto, this one may go to the Supreme Court. 877-989-2255 or aclj.org.
It's happening again. Our national motto, In God We Trust, is under attack in the courts. Those determined to banish our motto continue to make outrageous claims. Claims like our national motto is, quote, extremely offensive, quote, represents bigotry and persecution. The arguments are absurd. At the American Center for Law and Justice, we have successfully defended In God We Trust on numerous occasions. We defeated attempts to remove Under God from the Pledge of Allegiance at the Supreme Court and lawsuits against the national motto before. Now we continue the fight to counter the challenges to our national motto. Stand with the ACLJ in this important battle. Our national motto is ingrained in the fabric of our great nation. We will continue to defend In God We Trust, thanks to your support. Stand with the ACLJ now. Join the team that defends your religious and constitutional freedoms. Check it out online, aclj.org.
We talked about during this case that the Sixth Circuit relied on a case we argued at the Supreme Court called Pleasant Grove versus Summum. We represented Pleasant Grove on a Ten Commandments case, won at the Supreme Court unanimously. Here's a little bit about that case. Well, Ten Commandment litigation had been going on for decades and not very well. And we had this case coming out of Utah where this little town, Pleasant Grove, wanted to fight back. And this group came in to say, well, if you're going to display a Ten Commandments monument, we want you to display our monument, which was called the Seven Aphorisms, which were basically the anti-Ten Commandments monument. The idea being, if cities are forced to do this, they'll be putting them up all over the country and cities will just remove their 10 commandments.
This monument with the 10 commandments has been here nearly 40 years. The Summum want to put their monument with the 7 aphorisms right where I'm standing. To them, the issue is simple. If you allow one religious monument, you've got to allow another.
Pleasant Grove, Utah urges the justices to rule that just because it considers the 10 commandments historic enough to include in a city park, it doesn't also have to allow in a monument from a recently organized church called Summum, which believes Moses was given something called the 7 aphorisms before he got the commandments.
They gather inside a pyramid and practice the rite of mummification. This small band of worshipers call themselves Summum. The group, which has about 20 members, wants to donate a monument to the city of Pleasant Grove, which is near Salt Lake City, but the offer was refused.
What this really boils down to is closing a back door to shutting down displays of the 10 Commandments.
What the 10th Circuit did here literally threatens to undermine our celebration of American heritage in every little town and big city across the country, from the Statue of Liberty to Pioneer Park in Pleasant Grove, Utah.
Some say, like it or not, they've got a right to build their monument, thanks to the First Amendment.
We're talking about a public park. If we were talking about the front lawn of the City Hall, where government unquestionably controls and limits speech, that would be different.
The mayor of Pleasant Grove says this is not about religion. He says the Summum monument just didn't fit in.
This park is dedicated to the history of the people, the founding of the city, and significant people that have lived and contributed to the community.
I went with a very aggressive strategy. It was controversial at the time, where I said, no, look, this is the government making a decision to speak here. The government has the right to engage in an activity. If it wants to promote the Ten Commandments because it has historic significance to the community, both from a political standpoint, a moral standpoint, a religious standpoint, it's a perfect right to do it.
Mr. Sekulow, when you come upon this, if somebody comes upon this monument in the park, how are they supposed to tell whether it's government speech or private speech?
Well, of course, the face of it, Mr. Chief Justice, states on the face of the monument that it's presented to Pleasant Grove City in Utah County by the Fraternal Order of Eagles. And as far as a government speech, as far as ownership and control goes, under a more of a Johans analysis, different from Finley and Forbes in that context, here the government exercised control. After all, they allowed it, accepted it, and allowed it to be erected in their property. Under Utah law, all right, title, and interest to that property. Governments in the business of governing and determining the parks and the landscape of the parks make these kind of decisions.
Could you imagine a group coming in saying, well, you know, since you've displayed the Statue of Liberty, we're going to demand that the United States accept our monument, same height as the Statue of Liberty. We're going to call it the Statue of Tyranny, because that's how we view America. Would the United States be compelled to display the Statue of Tyranny, or could they say, no, the government is speaking, and we believe that the United States is a beacon of liberty, and that's why we're going to display the Statue of Liberty? Or at the Holocaust memorials that are throughout the United States in those parks, are you going to have to put a statue to Adolf Hitler because some neo-Nazi group wants it? No. When the government's speaking, it can determine its message.
If this opinion stands, they will now have to accept, but they will be forced to accept the counterpoint to every statue, every monument, every memorial.
A monumental decision today by the Supreme Court in Pleasant Grove City, Utah. There's a park and in it a monument to the Ten Commandments. A small religious group known as the Summum thought the park would also be a good place to put a monument of its own, but the city said no, so the group sued, claiming it violated its right to free speech. But today the High Court said not so. It ruled unanimously that parks are not required to take every monument they're offered.
I remember during the oral argument, Justice Ginsburg asking me about the Ten Commandments display, and I pointed to my right, because engraved in the Supreme Court frieze up on the wall is the Ten Commandments, Moses holding those Ten Commandments, and the words written in Hebrew.
This court has a depiction of Moses holding the Ten Commandments in the frieze of the courtroom with words written in Hebrew. That's not an endorsement of the religion or of the commandments, it's representative of the history.
And I said, you know, basically, if it's good enough for the Supreme Court of the United States, it certainly is good enough for Pleasant Grove. And 9 justices agreed with us. It was a great decision and a great result. It's rare you win a Ten Commandments case, and it's even rarer to win it unanimously, and we did, by God's grace. It was a great victory, still is.
You know, Jay, it brings me back to one of the things that we said in our brief in the Sixth Circuit, and that is we quoted the Mayflower Compact. This was the first document, 1620, 400 years ago, Jay, when we sat down and the colony in Northern Virginia was put together. The Mayflower Compact was the first document that sort of put together what the society was going to be like in the New World. And what does it start by saying? That William Bradford drafted. It starts as follows, not with anything else but this: in the name of God, amen.
Yeah.
We whose names are underwritten, and then it goes on and says, for the glory of God and the advancement of the Christian faith, honor our king and country, and in the presence of God do covenant and combine ourselves in a civil body politic for better ordering and preservation of the ends aforesaid. So this nation has been founded on the belief of a deity, a supreme being, and God, and we have defended and promoted that. The Sixth Circuit today has reaffirmed that.
All right, let's go ahead and take another call. We're taking your calls at 1-800-684-3110. Also, they says plaintiffs also argue that the currency statues are facially discriminatory because the motto plainly associates the United States with monotheism. Again, the court said that was not a basis upon which the motto would be deemed unconstitutional. Go ahead, Logan.
All right, let's take some calls. Let's go to Terry in Georgia online.
Hi, Terry.
Hello.
Hey.
Thank you for taking my
Sure.
call. My question, Jay, is, and you may have already answered it in the last segment, but I'm not really for sure. This is District 6 that you guys just
Sixth
won
Circuit.
in.
Yep.
And I know that they have the option of taking it up with the Supreme Court, and the court may not take it. But my question is, can a different district take this same issue and bring it before another judge? And their tendency is to just keep going until they get their way. So I guess
right. They're trying to find a judge, a sympathetic judge. So here's how it works. They have 2 options on appeal here. What Mike Newdow said, he's a good lawyer. What he could do is he could file for a motion to have the case reheard en banc, which, Andy, means the entire Sixth Circuit would hear the
all
case.
the judges of the Sixth Circuit, right?
Yeah, so that's one aspect. They could request for what's called a rehearing en banc. They do that and they vote, and if they decide they're going to rehear it, then they would rehear it. Or he could take it directly from here to the Supreme Court of the United States on a certiorari petition, which I would suspect would, I don't know if Mike, he may go through the en banc process first because he got a dissent here, and then take it to the Supreme Court and then hope that they get a review. So there's multiple ways it can go. But yes, it can be brought in other circuits. And in fact, there are other cases brought in other circuits. But I think if you look at existing Supreme Court precedent, I don't think there's a lot of risk here. I mean, I think you got to be vigilant because you get, we've had that before where a judge in a circuit or a district court judge rules it unconstitutional. But Harry, when you look at the opinion, it seems well reasoned.
Absolutely. And it's very consistent with Supreme Court precedent. In essence, the plaintiffs in this case are asking the courts to do exactly what the Supreme Court warned against in the Zorach case. That is to prefer atheism over religion, even to the extent of censoring the historical fact that the United States was founded upon a belief in God. So if you look at the Mayflower Compact, the Declaration of Independence, and the Gettysburg Address, they all contain religious references substantiating the fact that America's institutions presuppose a supreme being. So in essence, what the plaintiffs are seeking from the courts, they are asking the courts to erase American history.
Now, Than, you pointed out earlier, and I think it's worth reiterating, that we had a fight for this in the Capitol Visitor Center.
Yeah, we've had to fight for it in a number of cases. The Capitol Visitor Center was a unique one, Jay, because while so many of these cases involve the interpretation of statutes, including the National Day of Prayer and the national motto, both of which we go back to Congress and ask what they meant. In the Capitol Visitor Center case, Jay, they were challenging a statute that Congress had just recently passed. So you had the sitting members of the U.S. House and the sitting members of the United States Senate that had passed a law instructing the architect of the Capitol to include the national motto's inclusion, and then that did not happen. So we were able to go back to Congress and ask the very members who passed the statute what they meant by it. So the brief that we filed in that case carried a lot of weight. It was cited heavily in the decision that came down. And again, Jay, that is why it is now included when you walk through those doors of the Capitol Visitor Center. But Jay, I would say this, even in the cases of the National Day of Prayer or the national motto, when you go back to Congress and ask them, hey, what did you mean when you passed that statute? That carries a lot of weight when you present that to the court.
Well, that's going to do it for the broadcast today. I want to encourage you to sign on to our petition defending the national motto. Now, look, on this particular case out of the Sixth Circuit, it may go to the full Sixth Circuit, may go to the Supreme Court of the United States. When it goes to court, we can file a brief on behalf of all of our members that signed the petition defending the national motto. You could do that at aclj.org. That's aclj.org. That's the easiest way. Or 1-877-989-2255. That's 877-989-2255 or aclj.org.
It's happening again. Our national motto, "In God We Trust," is under attack in the courts. Those determined to banish our motto continue to make outrageous claims. Claims like our national motto is, quote, extremely offensive, quote, represents bigotry and persecution. The arguments are absurd. At the American Center for Law and Justice, we have successfully defended "In God We Trust" on numerous occasions. We defeated attempts to remove "Under God" from the Pledge of Allegiance at the Supreme Court and lawsuits against the national motto before. Now we continue the fight to counter the challenges to our national motto. Stand with the ACLJ in this important battle. Our national motto is ingrained in the fabric of our great nation. We will continue to defend "In God We Trust" thanks to your support. Stand with the ACLJ now. Join the team that defends your religious and constitutional freedoms. Check it out online, aclj.org.